Let's get back to the discussion on the PNID deal. More perspectives. We have guests from our Lagos studio. Is the law lecturer at University of Lagos, Mr. Wahab Shitu, also an EFCC legal consultant. Thank you for coming.
It's my pleasure. Thank you for inviting me.
And from our Abuja studios is the Director, Center for Constitutional and Parliamentary Studies, Mr. Emmanuel Anyegbolam. Thank you for joining us.
Have me in your studio.
All right, let's start with my guest here in Lagos. First, was it reckless, the manner in which Nigerian officials entered into the agreement with PNID? Would you call it that?
Well, reckless, if you will say reckless. But a new twist has been added into the old controversy. Nigeria is alleging fraud, alleging corrupt practices in the way and manner the entire contract was entered into. And this is very, very vital in determining the validity of any contract, whether local or international contract. Nigeria is saying that the events leading to the execution of the agreement, that money actually changed hands between certain, the international, partners component of PNID and the local, partners. And this is being investigated. There are also allegations there's a charge of money laundering and tax evasion against the company, and that it is because of these underhand dealings. There are also alleged underhand dealings in leading to the clauses inserted into the contract. And then this, they said, has also manifested in failure to bring the contract to the attention of the Federal Executive Council. And also, this is also the reason why some of the, things that ought to have, taken place before the contract was executed. And, again, as a result of these allegations, charges have been filed before the Federal High Court, Abuja, which has, and, the officials linked to the company have also pleaded guilty to the charges, leading to, forfeiture of the assets, order for forfeiture of the assets of the company, both in Nigeria and Virginia land in the UK. So you see, I think we have to also make a distinction between, an order has been made that Nigeria should pay $9.6 billion by a commercial court in UK. Again, there's a distinction between an order for payment and an order for the enforcement of the order. Now, attempts is being made by the company in the UK to enforce the order. And the UK court is reluctant to grant that, request without hearing from Nigeria. So as a result of that window, Nigeria now, ahead of the Thursday proceedings, you know that a federal government delegation has gone there. The Attorney General, of the Federation has spoken extensively that they have the EFCC report, investigation report, which shows conclusively that there's fraud and corrupt practices, and then you have also the judgment of Nigeria, which is going to be registered in the UK. Let's quickly
get the view of Mr. Anyegbolam in our Abuja studios. And my question to you is, the National Assembly is investigating, and that's the House of Representatives, several judgments in Nigeria last week with the Nigeria affiliate of PNID. A delegation now is in the United Kingdom. Do you hope that we will be successful in our cause as Nigeria, where we stand with regards to that judgment?
Well, actually, the issue involved is within a court of competent jurisdiction, we may say, over a contract between Nigeria and a firm. The right authority to be on this issue is the Attorney General, who has assembled his team at this particular hour and now has gone to the United Kingdom to face this issue as squarely on legal terms. But we must bear one thing in mind, that there is, by every expectation, a contract which went the other way around. And then since 2012, these parties went to arbitration and later had their award. It was the enforcement of that award that has come to bear. But the award actually raised a lot of issues because they were granted unprecedented all over the world. We have never had an award of this soon. And then they were given 1.2 million per day checking the number of months and every other thing involved. So what I will say is this. It is not actually, anyway, the National Assembly may come in anyway as a representative of people, feeling that 9.6 billion, what it means to a country that budgets barely 9 trillion naira per year's budget is a huge amount of money. So the sensitivity of the National Assembly, anyway, on that issue should not be overlooked. But meanwhile, it is an issue of law, which now the Attorney General is the appropriate authority to now make his presentation, either to appeal or in whatever form of defense he has. The politics of this issue, to me, we have struck before asking questions, but we have now come to the appropriate authority who will go now and do a special expert encounter with the issue before him based on his position as the law officer of the entire country. So that's my own submission on this issue. It is not an issue for media, neither is this actually or specifically that of the National Assembly. So the authority that is now qualified constitutionally, legally, and otherwise to handle this issue has come to bear with it, and I think we have to keep
But the question really was, you know, your hopes for the delegation in the UK. A lot of people are hoping that we can get out of paying that amount of money as it takes a toll on our reserves. But I'll come to you, Mr. Shittu, and that is diligent and due prosecution. The federal government is in the process of finding out all of those who are involved, collaborators. Can the people trust it?
Yeah, I think people can trust it. I think one thing that is in favor of this process is that time does not run against the state with respect to criminal proceedings. And that if allegation, if indeed it is established that there's some form of complicity, some form of fraudulent dealings in the way and manner the contract was executed. And then the first step has been taken. There, a court of competent jurisdiction. Remember, Nigeria is a sovereign country. In the same way UK is a sovereign country. We have our own domestic legal framework. In the same way UK has its own domestic legal framework. If we have press charges, and those charges have been established, leading to forfeiture, I think it will interest the UK court before, determining one way or the other the way the enforcement, proceedings will go, to also look at the circumstances surrounding this particular contract. The amount involved is huge. We are talking of $9.6 billion. That's a heavy toll on our foreign reserve, about 20% of our foreign reserve. And also, the UK, court will also be concerned about the likely implications this is going to have on our country. So they will look at all options. Like I said before, in addition to looking at the possibility of setting aside the judgment, and then ensuring that the forfeiture order is not, granted, Nigeria is also looking at the possibility of examining all the options, including the prospect of a negotiated settlement with the PNID.
Let's quickly get Mr. Yebolam's final 30 seconds on this, about the success of the delegation to the United Kingdom. 30 seconds.
I've not heard you very well anyway.
Mr. Yebolam, your 30 seconds, final 30 seconds on the success of the delegation in the United Kingdom. I
wish them the best of luck. And since they are experts who will now face the issue, like I said, squarely, and I wish that they will be able to resolve this issue to the best of the collective interests of Nigerians. All
right, many thanks, Mr. Emmanuel Ayegbolam, lawyer and director, Center for Constitutional and Parliamentary Studies, and thank you to you, sir, Mr. Wahab Shittu, lecturer, law lecturer, UNILAG, also EFCC legal consultant. Thank you both for coming on the program. That's how we wrap things up. Thank you for watching. Don't forget to join the discussion via social media platforms at Channels TV, at CTV Politics, #LunchtimePolitics. I'm Melissa Nwaka.